Good evening, everyone. I'm Jane Dixon Weber, the Director of Education and Support Services at the National Fragile X Foundation. I would like to welcome you to this evening's webinar, Guardianship for Special Needs Individuals and Caregivers, presented by Derek Graham. These webinars are made possible by your donations. Thank you for your ongoing support. The format for tonight's webinar, Mr. Graham will give a presentation on guardianship, and then we will open it to questions. Use the question box on the right side for your questions, and also use that box if you're having any problems hearing us. Now I would like to introduce Derek Graham. He is a principal at Resch, Root, Phillips & Graham, a law firm in Ohio with a specialty in special needs law. He says, I genuinely enjoy helping people avoid and fix problems that arise in their lives. In 2009, my wife and I had our first daughter who was born with Down syndrome. Like many of my clients today, we were inundated with information and felt overwhelmed. 9 years later, I spend the majority of my days helping similarly situated families understand the various resources that exist for families like mine. I find it very rewarding to meet with families and help them understand how to effectively and practically plan their estate. I enjoy helping families understand the resources available to them and how to get the most out of those resources. Good evening, Mr. Graham. It is a pleasure to have you join us.
Thank you very much. It's a pleasure to be here. So, welcome everyone, and I'd like to thank Jane and all of her colleagues at the National Fragile X Foundation for putting this together. Tonight's topic is one that's very important to a lot of parents, and to give you just a little bit about my experience with guardianship, I represent an agency here in the state of Ohio that serves as the guardian of last resort for adults with developmental disabilities. And so across the state of Ohio, they're the guardian for about 4,000 individuals. And this is a large nonprofit that has 100 or well in excess of 100 employees that play out these guardianship roles. But by virtue of representing them, I go to a lot of guardianship hearings and I spend a lot of time answering guardianship questions. Also, in my day-to-day private practice, I get a lot of families that come in that just have that kind of puzzled look in their eye of, my child's about to turn 18 and I'm not sure what's next. What happens when this child turns 18? What changes and what, if anything, needs to be done from a planning perspective? So I like sitting down with individuals and trying to figure out what is next. And guardianship is a topic that often comes to mind. It's also a topic where there's been a lot of change. Guardianship as it existed 20, 30 years ago is different than how a lot of states are viewing guardianship now. And a lot of the state support systems, whether it's your system that supports individuals with developmental disabilities or a more specialized support system, these support systems are changing the way guardianship is viewed. And also there are some laws and rules across the nation in different states that change the way guardians interact with support providers. And so tonight I'm going to do an overview of guardianship. And an overview of guardianship, I will admit up front, this is a little bit of a challenge because guardianship is a creature of state law. So the way guardianship works here in Ohio is different than how it would work in all of the surrounding states and all of the other states, because every state has a slightly different twist on what's involved with a guardianship. But I do find in doing a lot of research and also going to some national seminars that a lot of the nuts and bolts are similar, and there's a lot of similarities from state to state. So I'm going to try to avoid falling into talking about Ohio and keep this at a more global perspective. I'm also going to apologize up front if a lot of the questions are state specific. I'm not able to answer those. I'm licensed only in Ohio, and I can't give you a state specific question about an issue that exists in Missouri or something that goes on in Texas. So, all right, so guardianship. In my office, a family calls, they make an appointment, their child is 17 and a half, and in 6 months, this child turns 18, and they want to know what's next. What do I need to do? And they come in and they tell me, I'm here to talk about guardianship. And the first thing that happens when a family comes in, it kind of surprises them sometimes because we talk about how guardianship should always be a last resort. We talk about, the first thing we're going to talk about is, are there ways to avoid guardianship? In order to qualify for guardianship across the nation, on this slide it shows, it references incompetence, and that's the standard in Ohio. Most of the states, their standard is based on a capacity determination. Does the person have capacity to make decisions on a day-to-day basis. And so from a more national standpoint, the Uniform Guardianship and Protective Proceedings Act, which kind of governs a lot of different states, defines an incapacitated person to be an individual who lacks the ability to receive and evaluate information or to make or communicate decisions to the point that the person's ability to care for his or her health, safety, or self is compromised. And so, like in Ohio, we have this definition you have, which is very similar. Any person who is mentally impaired as a result of a mental, physical, developmental disability, or as a result of intellectual disability, or as a result of chronic substance abuse, that the person is incapable of taking proper care of the person's self or property. And so this is the definition that an individual has to satisfy or fall under in order to qualify for a guardianship. And so every single state, if you're wondering, do I need a guardianship for my child? One thing you may want to look at is, what is the definition? What is the test in your state? And I assure you, you can find that for every state on the internet. You can also, if you talk to a local attorney, they should be able to cite it to you. But we don't start with what is the definition of incompetence. The way we start this process is looking for alternatives and what else is out there. And so here is a list of some of the more common, less restrictive alternatives that are used to avoid guardianship. The first is supported decision making. If you Google or look up supported decision making, you'll find a lot of information out there about supported decision making. Supported decision making is a concept that centers around, just because an individual may meet the definition of being incompetent, does that mean he or she has to have a guardian? And I will tell you, I do a lot of teaching here in my state. I've done some teaching for the Ohio Judicial College, where I work with some of the probate judges and magistrates. And I've thrown this question out to large groups of judges before: just because somebody meets the definition, do they have to have a guardian? And there's a lot of disagreement about that. And if you look across the nation, there's a lot of states who are now recognizing, hey, just because somebody meets the legal definition of being incompetent, maybe they don't need a guardian, or maybe, and I'm saying incompetent, but they meet the definition of lacking capacity or whatever that is in your state, that doesn't mean they have to have a guardian. And so supported decision making is the concept that instead of asking, is guardianship necessary, it asks, what would it take for this individual to not need a guardian? And so if someone comes in and they sit down at my conference room table and they tell me they need guardianship, I'm going to start out by asking them, why do you need guardianship? And they're going to have an answer. And as a parent, I'm sure someday I'm going to have an answer to that too, because there's a lot of things that come to mind. But then the next question is, what would it take for you to not need guardianship? If there were supports, if there were the right people standing next to the individual, could he or she make the decision without a guardianship? We also have, in every state, we have different varieties of powers of attorney, financial power of attorneys, healthcare power of attorneys, living wills, talk about more end-of-life situations. Most states now have a mental health advance directive. These are all less restrictive alternatives that make guardianship unnecessary. The problem with these documents, and it's not necessarily a problem, but sometimes the roadblock to using these documents, is an individual has to have a certain mental prerequisite in order to sign these documents. So in Ohio, to sign a power of attorney, you have to have the capacity to understand the power of attorney. And so if you're coming to my conference room because you think your child lacks capacity in a lot of areas of life, it doesn't necessarily do any good for me to say, well, wait, let's have them sign a power of attorney, because if they don't have the capacity to understand the legal document, it's not a viable option. Some people do have that ability, though. There's a lot of individuals who do have the ability to sign those legal documents. And for those individuals, you've got to look at, do they understand the gist of the documents they're signing? And every state has a different standard for who can sign these type of documents. Ohio uses a very silly test, in my opinion, which is they say any individual with sound mind can sign these documents. And the term sound mind is not defined anywhere in law. So my position has always been, if the individual can communicate to me when I ask, if you need help with your finances, who do you want helping you? If they can clearly communicate that they would want their parent or their brother or their aunt or uncle helping them, then that tells me they have the capacity to understand this document. With healthcare power of attorneys, I ask the same thing. If you need help making medical decisions, who do you want helping you? If they can communicate clearly to me that they would want a specific person helping them making those healthcare decisions, then I'm going to explore further, why not try the power of attorneys? Why not try the power of attorneys in conjunction with supported decision making, where we look at what are the supports and the documents we can put around this person that makes guardianship unnecessary to begin with. If you think about guardianship, you're going into a courtroom and you're telling a judge or a magistrate, or in some states, you're telling a jury, because believe it or not, there's still a few states where you have to have a jury trial to determine whether or not someone needs a guardian. You're telling this judicial decision maker, hey, I want this individual who is an adult to not have the same decision-making rights that most of us have. That is an extraordinary remedy to ask a court to do. Courts will do it, and they do every day, and it's estimated we have about 1.5 million individuals under guardianship in the United States, but it is a drastic measure, and so it should be truly a last resort. And that's the purpose of these slides, is just to get across, hey, guardianship for some individuals, it's absolutely necessary, but to the extent it can be avoided, let's try to do that. The next thing, maybe the less restrictive alternatives don't work for your situation. So the next thing we have to look at is, what is the type of guardianship we need? Every state has different types of guardianship, but they use different labels. Most states label it as guardian of the person only, and then they also have a guardian of an estate, where you might hear the term conservatorship, or there are other different protectorship. There are other different titles in different states, but if you get past the title, really what they're breaking it down into is a guardian of the person, which is day-to-day decisions, medical care, residential placement. If there's behavioral issues, it's that. It's anything that pertains to the individual or their person. Or guardian of the estate, which is just what it sounds like. Guardian of the estate is referring to money and finances. If there's any kind of litigation, it's that kind of stuff. And again, this very much varies state to state. So I don't want to get too into the weeds on the types of guardianship, but I want you to be aware that there are different types of guardianship. And when you go to establish guardianship in your state, you don't want to take on any more types of guardianship than what you need to address the concern you have in your loved one's life. A lot of these types of guardianship, the more types of guardianship you establish, the more ongoing reporting requirements, the more tracking you have to do, the more responsibility you have, and it's completely unnecessary. And what I see a lot is parents come in and they want guardianship of everything, and they want guardianship of the estate. And I talk to them about their child, and their child doesn't have any money. So why do we need a guardianship of the estate for someone who truly does not have any assets to manage? Because a lot of individuals with developmental disabilities, their only asset to manage might be SSI, supplemental security income, or some other type of social security benefit. And that money is not generally managed by a guardian in any state, because that's a federal program, and that's going to be managed by a representative payee. So be aware that there are different types of guardianship, and you want to go for as few of those types as possible to address the need in your individual's life. The guardianship process, again, is very much a state-driven process. What you want to do is go to your county or district court, whatever may be in your state, and they should have standardized forms. I'm not aware of any state that does not have standardized fill-in-the-blank forms that start the guardianship process. That's not to say there aren't any, but most have those standardized fill-in-the-blank forms. And so you're going to go to your courthouse, or you're going to go online. Hopefully you're in an area where they're available online, and you're going to download those forms. Here where I am in Franklin County, Ohio, you can go to the Franklin County Probate Court website, download all the forms in a fillable PDF format, and then you're just answering questions about your loved one. You're submitting that paperwork to the court, and that starts the process. Now, one of the critical pieces of paperwork that you're going to be submitting to the court, and this is true in every state in one variety or another, is evidence from an expert, which would be a physician or a psychiatrist. Some states might allow a counselor or someone with different credentials, but there's going to be some type of evidence presented to the court from an expert. That's always been something that's a little bit puzzling to me, because I find a lot of times the experts don't know as much as the families and the individuals who see the person on a day-to-day basis. But nonetheless, an expert, a physician, a psychiatrist, maybe it's a pediatrician, maybe it's I just submitted one last week that was filled out by a cardiologist, and the cardiologist met the criteria to tell us as an expert that an individual needed a guardian. And so that gets submitted with paperwork to your court, and the process for submitting that paperwork may be different in every state, or will be different in every state. In most, if not all states, once you submit your paperwork to the court's going to do its own form of investigation. And that, in some states, that may mean that they appoint an attorney to represent the individual for whom you're seeking guardianship. In other states, like in my state, that means a person called a court investigator is going to come out and visit with your loved one. They're going to talk to them about guardianship. They're going to advise them of his or her rights and the fact that they can contest it, and do an assessment for themselves about whether or not they think guardianship is in fact necessary. So in whatever state you're in, there's going to be kind of an investigative phase after that initial volley of paperwork, where the court gets involved and looks into in a little bit greater detail, does this individual in the perspective of the investigator need a guardianship. Once guardianship is established, and guardianship is going to be established at a hearing, so there's always going to be a hearing. It's always going to be the applicant's burden to prove that the individual needs a guardian. And so the law doesn't require someone to prove they don't need a guardian. It's your job to prove they do need a guardian. One thing I talk about that I find with parents a lot is one of the things I despise about our DD system here in Ohio, and overall we have a really good system here in Ohio, but one of the things I don't like is throughout my child's life, at various points, I have to sit next to them at a table, and in order to get the services they need, I have to describe them in a very negative fashion right in front of them. That is very hard for a lot of parents. I have a phenomenal wife, and she's a phenomenal mother, but she's not ever allowed to go to any assessment my daughter attends, because if you talk to her, you would think my daughter is a few months away from becoming a rocket scientist and creating a new way to travel to the moon. I mean, she sees the best in all of our kids, and I love that about her, but that backfires in a setting where your child is being assessed for a service. That also backfires sometimes in a guardianship proceeding, and I call it the prideful parent trap, where it's hard for us as parents, especially if we're sitting at a table next to our child, to describe them on their worst days. We always want to describe them in the best positive light. And I always have to remind parents, when we go to a guardianship hearing, it means we've determined that there aren't alternatives that work, and guardianship is necessary. And so we want to be awarded as the guardian in this process. And to do that, we have to prove they need a guardian. And so even though it's painful, we have to describe our loved one on their worst day, not on their best day. And I hate telling parents we have to do that, but that is a fact of life in a guardianship proceeding. You're there to make sure the court knows what are examples of them making bad decisions. It's not time to brag about their good decisions, although you certainly want to be truthful and you don't want to overstate things, but you don't want to fall into that prideful parent trap. You want to describe them in an accurate, truthful way, but you do want to make sure the court knows what are the deficits. The judge, the magistrate, or as I said in a few states, the jury is going to determine whether or not the person needs a guardian. Once that determination is made, they're going to give you documentation that is basically your badge to the world that I have been appointed, or you have been appointed, the legal decision maker for the individual for whom you're the guardian. It's important that you let the right people know, hey, I've been appointed as so-and-so's guardian. I'm now the decision maker for this person. And I always try to stress to clients, being the guardian of an adult is different than being the parent of a minor. Almost every state has moved towards doing a better job of protecting the rights of individuals under guardianship. Before I get into the rights under guardianship, though, you also need to know that once the guardianship is established, and you've got that piece of paper that says, I am the guardian, I believe this is true in every state. It's certainly true in my state. that does not end your interaction with the courts. The courts are always going to remain involved in some supervisory or oversight capacity. I mean, they're always going to be involved in some way. In Ohio, the probate court is what's referred to as the superior guardian, meaning they have the final say on any decision a guardian makes. Now, in Ohio, probate courts and probate judges, in my experience, they have no desire to get in and micromanage the decisions of a guardian. They appoint guardians for a reason, because they want the guardians to go make all those decisions. But if some information is brought back to the court that a guardian's making the wrong decision, or there are certain decisions a guardian can't make, then that would have to be decided upon by the probate court as the superior guardian. But also, because they're the superior guardian, you have to keep them informed. You have to keep them informed about where the individual lives. In Ohio, you have to file an annual guardian's report and a guardian's plan. You also have to file an annual statement of expert evaluation and other documents that keep the court up to date on what's going on in the individual's life. So in your state, I would be shocked if any of you lived in a state where after guardianship is established, you don't have some ongoing reporting requirement to the court. And so you certainly want to know what that reporting requirement is. The number one reason guardians are removed as a guardian in the state of Ohio is they just don't file their reports on time. And courts get fed up with chasing them. And I understand why. You have moms and dads who are clients who say, I've been the parent of this child for 42 years, and you're telling me I've got to file this 2-page report every year, and the parent feels offended almost that they have to do this. And yes, they do have to do it. You want to make sure you follow through with your reporting requirements. Guardianship oversight. So the courts, as I said, they're going to continue to maintain oversight through your guardian's report. In Ohio, it's an annual plan, a statement of expert evaluation. You're always going to have to keep the court updated, at least in this state, and I'd be shocked if this weren't true in your state, if ever there's a move or relocation. A lot of states we're passing new laws saying if you're moving the individual into a more restrictive living environment, you have to get court approval first. And so like in Ohio, if you were moving your loved one that you were the guardian for into a nursing facility, then you actually have to file a motion with the court and have the court approve it. You have to give the court reasons why they would need to move into a nursing facility as opposed to continuing to live out in the community. Most states have a guardian complaint process where if the court is brought information from any third party that you, the guardian, are doing a bad job, they can investigate it, call you into court, maybe have a hearing and talk about what you're doing and what you're doing right, and unfortunately, maybe what you're doing wrong. And as I said, you do have that ongoing need to supply medical evidence. And then if you are the guardian for someone, especially a child, you need to do succession planning. The life expectancy of individuals with developmental disabilities has gone up tremendously in the last 20 years in this country. And it's life expectancy is something that a lot of parents don't want to think about. And frankly, my generation and the generation just slightly ahead of me were some of the first generations where statistically our children with developmental disabilities are likely to outlive us. And that wasn't true 30, 40 years ago. Parents, it's very sad to think about, but parents of children with developmental disabilities weren't nearly as likely to have their children outlive them. So if something happens to you, you want to have succession planning in place. If you don't know how to do that, when you go to your guardianship appointment hearing, ask the judge or magistrate, because I assure you, the courts want you to do succession planning. Because if you don't, it creates a headache for them. And so they're going to appreciate any succession planning you do. As I said a minute ago, there's been a big emphasis on the rights of persons under guardianship. There's been a big emphasis on protecting the rights of individuals. What we have found, and when I say we, there's been a lot of studies, and not by me, but there's been a lot of studies nationwide about the impact of guardianship on individuals. And I think some of the studies are great, and some of the other studies just make me scratch my head and wonder what in the world they were studying when they did their study. But one thing I do agree with is an individual under guardianship, you've got to respect their dignity of risk. And what I mean by that is we all have bad habits. And what I find sometimes, and unfortunately even within my own clients, when we become someone's guardian, we view ourselves as their decision maker, and we view ourselves as our role is to not let them make mistakes or to protect them from any mistakes. We all have bad habits. Everyone listening to this webinar has a bad habit. One of my many bad habits that I'll admit to is I drink way too much pop, way too much soda. My wife hates that I drink pop and soda. It drives her up the wall. It's a terrible habit. She's right. Every ounce of pop I drink is full of chemicals. And someday I'm going to get a diagnosis of some kidney problem or something like that, and I'm never going to hear the end of it from my wife. If I ever need a guardian, I would want it to be my wife. If I have a traumatic brain injury and I need a guardian, then I would certainly want my wife to be my guardian. That bothers me a little bit though, because I know if she's my guardian, I'm never going to see another can of pop. She'll move every mountain she has to make sure I don't get any pop in my life. And that's not the role of a guardian, because if she does that, she's breaching her obligation to respect my dignity of risk, because all of us have those bad habits. And as a guardian, we're not there to be a sheriff and to cut out all their bad habits. That doesn't mean you've got to stand back and watch if they want to play in the street. Obviously, if there's a major health and safety concern, you've got to get involved. But we have this bubble effect where a lot of times guardians try to put the individual they're serving in a bubble and protect them from anything and everything that could go wrong. And they, I think, unintentionally strip away the dignity that comes from taking risks. And every time I drink a can of pop, I'm taking a risk that the chemicals in this are going to backfire on my body someday and hurt me. And you want to respect the fact that just because it's not a bad habit you have doesn't mean it's not a bad habit that they should have the right to enjoy. Or they should have the right to exercise. And that's a very fine line. It's very hard for parents. And it's one that I certainly don't look forward to navigating myself someday, because that one is tough. Another thing that comes up a lot is administration of medication. So when we talk about healthcare and medical care, a lot of individuals think once I'm the guardian, it's my way or the highway. And that's not necessarily true. There's a lot of different laws out there on medication and healthcare decisions. And as guardians, a lot of times in most states, we have the ability to consent to healthcare. And so it's our job to decide and provide that informed consent to healthcare. That doesn't mean we can necessarily force healthcare on them against their will. It depends on a number of circumstances, what state you're in and what the laws are of that state. But I know there are some federal rules and regulations that come into play with this, and you can't always force treatment on someone who doesn't want it. This comes up most often on individuals who have mental health diagnosis, where they really are oppositional or defiant to certain medications. Other guardianship issues that come up. So, termination of guardianship. Guardianship can absolutely be terminated. Sometimes individuals with developmental disabilities, it just takes them a little longer to reach maximum maturity. Maybe they're not ready to be an adult at 18. Maybe they're ready to be an adult when they're 25. And so guardianship can be terminated. It also may be that guardianship can be terminated because you find that as they get older, they are more capable and have more capacity to sign or get involved in some of the less restrictive alternatives. I'm pleased to say that the number of guardianships that are being terminated are going up on a regular basis, at least in my experience and what I see across this state. I still caution parents that guardianship in some respects is like a tattoo, in that it's a lot easier to put it on than it is take it off. It doesn't mean it can't be taken off, but it's a lot easier to establish guardianship in my experience than it is terminate it once it has been established. So that's another reason you don't want to sprint into it unknowingly. I always get a lot of questions about the liability of a guardian. If I'm the guardian for my son who's 19 and he sets the neighbor's house on fire, am I going to get sued? Well, liability of guardians is going to be slightly different in every state. And so I can't give you a one-size-fits-all answer to what liability a guardian has. Generally speaking, though, and again, this is not state specific, so you can't take this to the bank. Generally speaking, you're only going to have liability for information and duties that you mismanage. And so if I'm the guardian for my son who's 19 and he tells me, hey, I got a can of gas in the garage, and as soon as my providers leave my apartment, I'm going to set the neighbor's house on fire, and I say, oh, shucks, don't do that, and then I go to bed and he does it, then I have not handled the information I had very well, and I probably do have some liability for mismanaging my duties and not acting in a more appropriate fashion. If I'm the guardian for my son and he's never set anything on fire ever in his life, and for the first time he slips out of his apartment and sets the neighbor's house on fire with no reason for me to suspect that was going to happen, I probably don't have any liability because I haven't mismanaged any information. I haven't ignored any duties. A lot of parents wonder, well, I have to establish guardianship because I don't want my child to come home from school tomorrow or come home from their day program or maybe their work environment and tell me that somebody sold them a car and they signed a contract to pay $10,000 for a car, or I signed up for a credit card that I've maxed out. And parents worry that, hey, what happens there? In most states, a determination of guardianship creates a presumption that the individual does not have the capacity to enter into a contract. And again, this may be different in every state because the requirements to enter into a contract are different in every state. But generally speaking, having guardianship creates a presumption that you're not able to sign a legal guardian or a legal contract. Now, conversely, in most states, being adjudicated as needing a guardian does not mean you cannot have criminal liability. So at least I can speak for Ohio, the determination of whether or not you can stand trial for a crime and whether or not you're competent to stand trial for a crime is a different standard than whether or not you are incompetent for purposes of needing a guardian. That's never made sense to me, and has created a lot of what I can believe are inappropriate situations where the wrong people are sent to prisons and facilities that doesn't benefit anyone. But just be aware that having someone adjudicated incompetent doesn't mean they can't ever possibly be convicted of a crime. And maybe they can't in your state, but I know in a lot of states they can. Guardianship does not in and of itself automatically block marriage in most states. Some states it does, other states it does not. In Ohio, if you are under guardianship and you go in and get a marriage license and you get married, it automatically terminates the guardianship. Now, marriage is itself a contract. And so theoretically, if whoever's issuing the marriage license is paying attention, that would set off a red flag. And that's where ultimately, at least in this state, the court would hold a hearing to determine whether or not you have the capacity to get married. Likewise, engaging in sexual relationships and having children, all that stuff, the things that make all of us parents cringe when we think about, all of those are different capacity standards that may or may not line up with your guardianship standards. So at least in Ohio, meeting the definition of incompetent doesn't mean you don't have the capacity to engage in a sexual relationship. You get into, is it consensual and do you have the capacity to understand and all these other things. And they're certainly not mutually exclusive. So you get into some sticky situations there, and just be aware that guardianship doesn't mean that they can't date. It's a whole different standard for all of that stuff. So guardianship resources. So I want to open this up for questions. So if you have questions, now's a good time to start sending them in. But I want to leave you with some resources, and these are some good national resources you can look at. One is the National Guardianship Association. And you've got the website there that you can go there to find some additional information on best practices, national standards, things of that nature. Also, most states have a state guardianship association where you can get a lot more resources. The American Bar Association has a lot of good resources on guardianship and guardianship law practices. I would also encourage you to, again, go to your local court and ask for their standardized forms. Talk to an attorney. In a lot of states, in a lot of counties, if you're hiring an attorney to help you with this process, I'd go to a local attorney and I'd ask him, how much guardianship do you do? How often do you represent people pursuing guardianship? Make sure you get a clear understanding up front what the attorney charges. It may or may not be worth your money. And at least in Ohio, if you're doing guardianship of the person only, I tell all of my clients, you do not need to hire me to establish guardianship. It is hiring me as a function of convenience and helping or having me help you make the process smoother and easier and more predictable. But there are certainly a lot of parents who do it without an attorney and save that money on legal fees. And I don't think that's a bad course of action whatsoever to do it without an attorney, at least in this state. Now, I also tell clients in this state, if you're doing guardianship of finances, then at least in Ohio, I do believe you definitely need to have an attorney involved, because that can get a lot more complicated. So that's my 30-minute global overview on guardianship. And that's about as quickly as I can talk through an overview of guardianship. And I hope it's been helpful to you. We're going to open it up now to questions. And my understanding, Jane's going to read out some questions, and I'm going to do my best to answer them.
Thank you, Derek. That was great. So we had one question come in. Who will make medical decisions for someone who is or may be incapacitated and there is no guardianship, such as for a health issue?
It's different in every state. So to provide health care, to provide medical care, the healthcare provider needs consent. And to give consent, again, requires capacity. And most states have a statute or provision that says if someone is, they do lack capacity and they can't give consent for their health care, some states have a next of kin statute where the next of kin in an emergency situation can give consent. There are also some states that say the chief medical director or there's someone designated in the hospital, whoever the boss doctor is in the hospital can make the call if it's a life and death situation. And then there are other states where you're stuck because you don't have someone there who can make that decision. And for the families that reject and push back against supported decision making, that's one that comes up pretty frequently. They say, well, this supported decision making stuff sounds great, but what if my child gets appendicitis next week and refuses to have an appendectomy? I'm not going to let my child die over appendicitis. And I always tell clients you're right. That is something that could happen. You know your child. Would you be able to work with them if your child does have appendicitis? And would you be able to support them in a way that helps them decide to have the appendectomy? And if the answer is absolutely not, then maybe guardianship is right. But I prefer to look, especially at some of the alternatives, don't necessarily think about why it won't work, but also think about some of the reasons that it will work, because you will be there, you will be with them at the hospital, and you can talk to them and you can reason to them. And every child's different. So for some individuals it works, others it doesn't. But that's a great question that there's no clear answer to.
I got you. And I just want to add that I think many of you know that we do have full guardianship for our son, and I carry my papers with me wherever I go. I've got some in the car because we have had an unexpected medical incident, and the first thing they said is, you know, your son's an adult, and so I had to show them that I am his legal guardian before they would even talk to me. So, okay, what happens if someone objects to guardianship?
So it depends on, again, what state you're in, but it's not uncommon for someone to object to guardianship. Ultimately, in most states, the judge, magistrate, or jury is going to make a determination what's in the best interest of the individual. So if I apply for guardianship of my daughter and my brother objects, saying Derek shouldn't be the guardian, at least in Ohio, he would have to come into court and show the judge why I should not be the guardian. Most guardianship proceedings, and this is true of most states, it's a two-phase proceeding. Phase one, does the individual need a guardian? Once that's established that yes, they need a guardian. Phase two, who's the right person to be the guardian? A lot of states require background checks. And so if someone's there objecting, it's going to be their burden to show why is the person who's applied not fit. And a lot of times the judges will say, well, if this person's not fit, who is? Have you applied to the person objecting? Sometimes you get into situations where service providers, maybe it's in Ohio, we have county boards of developmental disabilities. Someone like that is objecting, saying this parent does not have the best interest of this person at heart, and they should not be the guardian. And all that is stuff that the court's going to consider and take into account when determining who the guardian should be. Another good question.
Okay, I was just kind of looking ahead to see what else is coming up. Can you just briefly tell us the difference between guardianship and conservatorship?
Sure. And again, I know you guys are probably sick of hearing this, but slightly different in every state. Generally speaking, a conservatorship is someone who still at the end of the day has decision-making authority, but due to maybe a physical disability or just an inability to communicate, cannot get out and make the decisions for himself or herself. And so someone else is designated and given the authority to make decisions and to act on that individual's behalf. So guardianship, and contrast that with guardianship where someone else is appointed to actually make the decision. A lot of times with conservatorship, the individual still has the final say on decisions. Someone else is just given authority to get out and help and make those decisions. Whereas with guardianship, someone different is appointed to be the decision maker. But now, again, that varies state to state.
Okay. For a child with, or I'll say for an adult with an intellectual disability living in a residential facility, the guardian can still be the parent, correct? Not the facility management.
In fact, in most states, a direct service provider cannot be the guardian. And that's more of the transition we're going to. Here in Ohio, if you are a paid provider, then you cannot be the guardian unless the court waives that conflict of interest. Because anytime you have someone who's being paid to provide a service and they're also the decision maker, that's a really ripe situation for abuse, where the individual basically has a conflict of interest. If I'm being paid to be the provider, or even if my wife is being paid to be the provider and I'm the guardian, I'm a lot less likely to get in there and complain and cause there to be changes if there are things that are wrong happening, especially if it's my wife. So that's one reason that a lot of courts and a lot of states are passing laws. Ohio just did 3 years ago saying you cannot be a direct service provider, which would mean a residential provider or a day or a homemaker personal care provider, and also be the guardian, unless, in Ohio anyway, unless you're an immediate family member and the court holds a hearing and waives that conflict of interest.
Wow, okay. We have completed estate planning, including a trust for our adult child. We don't know how to formulate a succession plan for who she'll live with and rely on. We have POAs, power of attorneys, but she has no guardian. What resources can you recommend to us for succession?
So a lot of what we do here at my firm is special needs planning and planning for loved ones with developmental disabilities. And one of the terms I use a lot is roadmap. And when I meet with families and we do wills and trusts and power of attorneys and all the legal documents, I always tell them that's great. But there's nothing as important as having a good roadmap that's written down. And this can be something as simple as you opening up Microsoft Word and typing out everything someone needs to know about your loved one if something happens to you. And in my firm anyway, it's kind of a questionnaire format that leads into a narrative, and we have clients fill it out as part of the estate planning process and give it to us so we can review it and give them feedback. Because I always like to say, even though sometimes it's personal and it's hard for people to hand that information over to us, one, it makes you do it, and two, if I have a lot of questions, everyone else in your loved one's life, they're going to have a lot of questions when you're not here. And so you've got to think ahead about everything from where is your loved one going to live when you're no longer alive, who's going to be taking care of them, what's the medical information, and we give that to clients in a Microsoft Word format, and then we tell them get it out once a year and update it. And don't try to map out the rest of their life, because you'll drive yourself up a wall trying to do that. Plan out the next year. So if you pass away this year, what does somebody need to know to help your child or loved one through the transition of you not being here? What are providers that you like? What are experiences that have been negative? What do you not want? What do you want? Because again, the trust and all the legal documents, very important. That protects your eligibility for programs. But from a practical standpoint of what's going to happen the day after you're here, you've got to write that stuff down. And we always call it our roadmap. And it doesn't have to be anything fancy. I don't have any great resources to send you to online other than to just tell you, get out pen and paper and write it down, and then update it frequently. And think about, I always tell clients, because some clients roll their eyes and say, oh, it sounds like a lot of work doing that. And I tell them, if you knew you were going to pass away tomorrow, as the parent of someone with a developmental disability, if you knew you were going to pass away tomorrow, when not crying and hugging your child, you would be making videos and leaving notes and all this stuff because you'd be worried about what's going to happen. And as a parent, it's absolutely terrifying to think about your children here without you. And I think that's even more so the case when your child has a developmental disability.
So, Derek, planning, just, what a great idea for parents to sit down and write out a plan for a year. Because I think what happens is it becomes so overwhelming to think about, oh, I have to write down everything that I think of that will ever happen forever. But if you say, no, let's just do it a year, that's great advice.
It is, because you're absolutely right. If you try to plan out, my child is 10. If I sit down and try to write out what I want for her when she's 30, it's not going to make sense, and it's not going to be useful, and it's not practical. But if I know as a 10-year-old, these are the issues we've been dealing with in her IEP the last year. These are the family members she's really close to right now. These are the good friends at school. These are the bad friends at school. This is the, we really want her to stay in this school district. I mean, you've got to write that stuff down. You're going to say who you want the guardian to be and all that stuff. In most states, when we talk about because the original question was about guardianship succession, most states do have a statutory way to designate a successor guardian. In Ohio, only a parent can designate a successor, and it has to be in writing, done a certain way. So we have clients sign a document designating who we want the successor to be, and then we file it with the court. Every state's going to be a little bit different. If you are the guardian for someone and you're worried that, hey, if I die, it might be Uncle Joe that applies for guardianship because he wants my son or daughter's SSI money, and we don't think he'd be a good fit. I mean, if nothing else, again, get out pen and paper and write down, we don't ever want Uncle Joe to be the guardian. Here's why, and attach it to your next guardian's report or whatever you're filing with the court. And if, as the person asks the question, and if you just have power of attorneys, write all that down, put it in bold, and make sure it's attached to your trust and all that paperwork so that the people who are coming along behind you to help with your finances see that and can help advocate for that.
Okay. The person at Social Security told us that the representative payee legally is higher than guardian or any sort of power of attorney. Is that true?
So this gets into a really sticky jurisdictional issue. Guardianship is established by a state court. Social Security is a federal program. And hopefully there are no judges on here listening, and if there are, hopefully they're not in Ohio, because they don't like it when I say this, but it is true. A state court judge, technically speaking, does not have jurisdiction over federal programs. And because Social Security is a federal program, it regulates itself. And so, no, a state judge would not have jurisdiction over Social Security monies. Now, having said that, good luck telling that to the judge, and I would certainly be prepared to answer for the funds to a judge if asked to, because not all judges agree with that, but that is the correct answer. And the person at Social Security, from a technical law school textbook standpoint, they are correct that a state court judge does not have jurisdiction over federal monies, but good luck standing in front of one and getting them to agree with you on that.
Thank you. Can you elaborate a little bit on the legal documents or requirements for supported decision making?
I can, and I'd encourage you to look. There's I should have put the website up. There's a website for national supported decision making, and it's really growing across the country. And some states have actually codified supported decision making in their statutes and in their regulations, and it's really growing in popularity. When I talk about supported decision making, it doesn't have one specific definition. And so it could mean that, hey, my child's turning 18. I don't want to pursue guardianship. I want to, they're surrounded by people who are helping them and they're doing just fine. And so maybe it means they come in and their child signs a HIPAA waiver, and their child signs an education waiver, and they sign a release giving the parents access to all the information the parents could possibly want information to. And then the parents use that information and just their general relationship with their child to help their child make decisions. Here's a good example. I had a client that came in on Monday of this week. I'd never met the person before, and a mom came in actually the husband wasn't here, it was just the mom, and she came in to hire me to pursue guardianship. And so I started the meeting by saying, tell me about your daughter. Well, her daughter was 29 years old. And I said, well, why do you need guardianship? And she said, not really sure, but the county board, or my caseworker, I have a new caseworker, and they told me I really needed to get guardianship. And I told her, I said, and her daughter, in talking to her, I think her daughter would clearly meet the definition of being incompetent. But from age 18 to 29, her mom had been with her, had helped her make all of her decisions, and had never run into any barriers. Now, that's not the experience every parent will get. There are certainly other parents who have much worse encounters where they need help in getting access to information. But this parent had done supported decision making for 9 years and not even realized it. And she had no legal documents. She was just there as a natural support, helping her daughter. And she'd been to every doctor's appointment. She's the reason her daughter takes her prescription meds. I mean, she's the quintessential great mother doing great mothering. And now here she is wanting this legal title just because a caseworker told her she needed it, not because anything was going wrong in her daughter's life. The essence of supported decision making is when your child turns 18, try it without guardianship. See if you have the same experience and give it a chance to succeed and not be consumed with the fear of failure. Now, I'll tell you as a parent, a lot easier to say than do. I mean, a lot of you are closer to making this decision with your kids than I am mine, but I can already tell you that's going to scare the heck out of me if I end up doing that when my daughter turns 18. So there's no set document involved in supported decision making that applies nationwide. Now again, some states have recently passed laws where they have specific supported decision-making documents where a person can say, these are the people I want helping me, and it does help break down some of the barriers to information, because a lot of times it's that access to information that trips up supported decision-making.
But when that woman, for example, went to the doctor with her daughter, so I guess the doctor never said, never questioned whether why she was there, or that the fact that she was there.
I can't say what exactly happened, because I had kind of the same reaction. And in talking to the mother, her daughter has had 4 surgeries since she turned 18, and
oh wow,
she has never run into a problem. The daughter gives consent, and the daughter is not working. She's in a day program all day, and I hate using these relative terms, but she would fall in the moderate to lower functioning category. And the mother it's always worked. Now, I have a feeling, and I don't know, because again, I wasn't there, that healthcare providers at different points with some of these surgeries probably made some assumptions that weren't true, and no one was the wiser to really clarify it, but I don't know. I think a lot of individuals, I've talked to one judge before who has a child with Down syndrome, and I had done a presentation on guardianship and rights, and he came up to me afterwards and said, I would never pursue guardianship of my child. And I said, why? And he said, well, my child's, I think he told me at the time, like 35, and I've never needed guardianship, and I don't want all the hassle of dealing with guardianship. And he kind of gave me a rant about why guardianship wasn't necessary and not all it's cracked up to be, and how great his experiences have been with his son. Now, in that case, it's easy for me to rationalize that a federal judge is going to have a much easier time getting his way in places than what your average parent is. But, different people have different experiences.
Well, but her daughter could give consent, and then and that would be okay, wouldn't it?
Yes. Well, you walk a fine line there. The daughter could, I don't know what I just did. The daughter could give consent, and apparently did give consent. The issue becomes if you lack capacity to give informed consent, a physician shouldn't accept your consent. And so in this case, the physician obviously is sitting there talking to the person and their parent, and they're on the same page, and the doctor who's doing this surgery felt comfortable that he had the necessary consent to do the surgery. And in reality, he did, because everyone was on the same page.
I gotcha. Okay. We got a few more questions because I do have another one that, let's see. All right, so does a photo or a digital copy of the official guardianship papers work for emergencies? So like I told you, I think I mentioned, I actually take a hard copy, and it is a copy of the original documents. It is not even an original document that I carry with me. But if I take a picture of it and put it on my phone, is that acceptable to places?
That, at least in Ohio, that would be up to the person you're showing it to. A letter of guardianship is a court order, and at least in Ohio, that's a court order saying this person has been determined the decision maker for this other person. And so to ignore the letter of guardianship, depending on the circumstance, may very well be violating a court order that says this is who the decision maker should be. Whether or not a certified copy would need to be presented in hard copy form, really it's dangerous to say yes or no, because that's going to be very different state to state. And even in this state, if I was, and I'm the guardian for multiple, or been the guardian for multiple individuals at different points in my career, and I could take a letter of guardianship to 2 or 3 hospitals here in town, and they could care less whether it was a certified copy, or if I showed them a picture on my phone, they could care less. They would take it and it would work just fine. And then there are others that are more sticklers and say, not only do we want a copy, we want it to be the embossed certified copy. And then that's kind of a headache. But so it's hard to say.
Okay.
As a guardian, I think a best practice would be to do just what you're doing, which is to keep a hard copy in the glove box, so that if you ever do need it, you can grab it and you have it at your disposal.
Okay. If a minor child is protected by a restraining order, will that abuse protection order terminate when the child turns 18? Or can a guardian maintain the order?
That is very much enveloped in state law, and I'm not even comfortable answering it because of so many variables. And I don't mean to be evasive, and I apologize to whoever asked that question, but I don't know it's going to have to be the question. I would talk to an attorney in your state that's there in your local community about the answer to that.
Okay. No, I think that's fair. Can there be more than one guardian?
In most places, yes. In Ohio, we have 88 counties, and I would say about 70 of the 88 will appoint co-guardians. A lot of counties view it as, yes, we'd love to have co-guardians because it makes succession planning easy. A lot of times you get mom and dad who are co-guardians, and then like I just had one where mom and dad were co-guardians. They're getting up in age. They're now in their early 80s, and dad was just diagnosed with prostate cancer. So they came in last month, and dad resigned as guardian, and at the same time he resigned, their other daughter applied, and now it's mom and the other daughter are co-guardians. And that is a great way to do succession planning, because now someday when, dad's still there obviously and he's involved, but he's got a lot on his plate. And so someday when something happens to mom, sister is already in place as a co-guardian. Not every court will allow co-guardians, because once you have co-guardians and they disagree, it creates a real mess for the courts. But most courts, in my experience, at least here in Ohio, will appoint co-guardians.
So if you have, like in that example that you just gave where the dad resigned and they added the daughter, do they actually have to go back to court for that, or can they file paperwork?
In Ohio, you have to have an appointment hearing. So you file paperwork, and then we had the dad sign a document saying, I resign as guardian. And we filed it along with his other daughter's application The court scheduled it for a hearing because the other daughter has to take an oath and sign an acknowledgement of duties and all this stuff in Ohio. And so we went in, and it was about a 15-minute hearing, and dad was no longer guardian and the sister now was, and it was a very good, positive family experience.
So then they just get new papers that
Yes.
that talk about that. So the wife is still there, but then the dad is off.
Yes.
You know, going back to that one question, I think it was one of the earlier questions where, like, what would happen if your adult child became ill and you don't have guardianship? Is there such a thing as emergency guardianships?
In most, if not all states, there is emergency guardianship. Ohio has emergency guardianship. I'll tell you, it's a pain and the courts do not like it, but they absolutely will do it. It takes a true emergency. And it's a higher standard to meet, because in Ohio, I can apply and become guardian for someone that doesn't even know I've applied to become their guardian. And so it's a very high standard to walk into a courthouse and say, my daughter's not here, and no one from the court's ever met my daughter, but take my word for it, she meets the definition of being incompetent. It's highly scrutinized, as it should be, but when necessary, courts will do it. And a lot of times it involves a medical situation where someone's making a very poor medical decision, or someone's at incredibly high risk of being taken advantage of with their finances or something like that, and you need to get in there and stop it immediately.
Okay. One more question that I wrote down as you were going through is, so you mentioned that, you know, on the annual reporting, which we do have to do, that you have to make notice that, you know, or notify them if you move. Do you have to notify them before you move or after you move?
In Ohio, you have to give notice 10 days prior to a move if it's what I call an apples to apples move. So if you're moving from one house to another house, you have to give them 10 days notice in advance of the move. And I'm sorry, that's for the person under guardianship. If the guardian moves, then you just need to let the court know as soon as possible after you move. If you're moving the person under guardianship to a more restrictive setting, something like a nursing facility or something like that, then you have to tell the court in advance and get the court's permission to do so. And again, that's going to be a little bit different state to state.
What if you move from one state to another? Like, let's say, like we have guardianship of our son and we move from Colorado to Missouri. We're going to move back to Missouri by my family. What would I have to do?
There is a Uniform Transfer of Guardianship Act that most, but not all states have adopted. And so in most states, there is a statutory process where a guardianship can be transferred from one state to another. There are exceptions, and if you're moving to one of the states that has not adopted this act, you would basically have to establish guardianship in your new state, terminate guardianship in your old state, in that order. And so I would tell you to start by talking to your court there where you've established guardianship. Let them know you're moving. Make sure you have their blessing. One thing to keep in mind, most individuals under guardianship who have developmental disabilities, a lot of them might be receiving Medicaid or some form of Medicaid waiver, and that does not transfer state to state very well at all. In fact, it doesn't transfer state to state. So just be aware. I always tell clients you can move state to state, but there's a lot of homework involved in doing so.
And I think we'll probably make this the last question. Could you talk a little bit about how soon should parents start applying for guardianship? You know, whether they do it themselves, or maybe they take a class at their ARC, or have to hire an attorney. What's a good age to start? A good age of the child to get this started?
So emancipation happens at age 18, and so that's when the child becomes an adult. And so I would start in advance of that age. And so here in Ohio, I tell clients, if you're pretty positive that you need guardianship, we're still going to have the conversation about how to avoid it. But if you're pretty positive you need it, come in about 6 months before the 18th birthday so that I can walk you through the process, give you a list of all the paperwork I need, and then it gives you plenty of time where no one's rushed or stressed to gather that paperwork. And then I'm going to submit the application to the court about 6 to 8 weeks before the birthday. In most states, the individual has to be served with notice of the guardianship application, and they can't be served with that until they're 18. And so, for example, in Ohio, your best case scenario is that you would be appointed guardian about 7 days after their 18th birthday. And so you've got that little window where there's going to be a gap where sometimes you do have emergency guardianships. But general rule of thumb, if you're going through an attorney, I would start about 6 months before their 18th birthday.
Okay. Wow, Derek, this has been so informative. I'm so appreciative, and I can speak for 50 of the families who are still online listening. So thank you so much for all your information.
Oh, thank you. Fun to do.
I mean, this is a hugely important topic for our families. Families are saying thank you. So I also want everyone to know that Derek will be back in 2 weeks to discuss special needs trusts, and we hope you can join us, and we'll be sending emails out on that. Derek, can you maybe give us a brief couple sentences on what you're going to talk about in 2 weeks?
Yeah, I'd be happy to. So everyone has an estate plan. You either have the estate plan that you create for yourself, or you have the estate plan that the government's created for you. If you have a child with a developmental disability, then you're going to be in the world of Medicaid and SSI and government benefits, and the estate plan that the government's created for you does not work in that world. So you've got to design your own, and you've got to know what tools are available that help you preserve and protect eligibility for those benefits. And that's what we're going to talk about.
Oh, wow. It's going to be another good one. You won't want to miss that. I mean, so anyway, I want to say again, these webinars are made possible by your donations. Please consider making a donation at fragilex.org. And Derek, do you have any parting words after our talk tonight?
No, I just really appreciate you guys having me, and I hope everyone's able to take something away from it. And thank you all for being here.
I also want to let you know, if any of you know, a recording will be emailed out most likely sometime tomorrow. If you have any questions, send me an email, and I will put together a group of them and send them to Derek if we need to, and then and I'll get you an answer. But until then, this is Jane Dixon Weber with the National Fragile X Foundation, and I thank you all for your time. And Derek, again, thank you so much.
Oh, thank you. Have a good night.
Good night, everyone.